Whenever we deal with an estate plan, we always ask, I think the question that you have to ask whenever you're doing wills or trust for family, I think now it's estate planning 101 to ask, is anyone who's part of this plan, whether it's the testator, testatrix, or beneficiaries, anyone have a disability? Because, the disability, if it's the testator or testatrix, obviously you're going to have issues related to capacity, and you need to know that, although typically in your interview you're going to see that. But you also need to know, do any of the kids have a disability? And even if in your questionnaire they don't say yes, I really recommend, and this isn't just because I do a lot of disability law, it's because I do a lot of estate planning. I always ask, do you have a little conversation? Okay, what's Jimmy doing now? Where's he in school? He didn't graduate from college. How come? Because I have had families, sophisticated families, say the child had no disability and the kid has a major mental health issue that calls for a special needs trust because the kid will dissipate the property that they really didn't mention in any of the questionnaire questions. I mean, we had one recently where, and I believe the family were physicians, and said, no disability. And it turns out, the kid's been diagnosed with schizophrenia and got kicked out of a couple schools and can't manage money and can't hold a job. Well, that sounds like we need a special needs trust. Whereas if I just kind of took it off what they said off the questionnaire, said no disability, I'd just make the kid a beneficiary and go on our way. And that's, wouldn't have served that family very well or that kid very well, because it would have disqualified him for medical assistance, which the family was in the process of applying for. So I think where there's, and then once you have any kind of a suggestion that the child has special needs, if the child either is in school or recently left within the last maybe 3 years, I think if the family doesn't have educational records they can get to you, get them to sign a release. And the release can be just as simple as, I authorize the release of Jimmy's school records to my attorney, Bill Blass. And the school district will send you the records they have. Now, once they graduate, they don't have to keep those records forever. But while the child's in school, they do have to keep all of the records. So, and oftentimes the family will have the IEPs and evaluations that the school district has completed. So I think all of that is useful in deciding, okay, what are we going to do with this child's share? How are we going to distribute the money for this child with a disability? And the typical tool that you use is a special needs trust. Now, there are 3 basic kinds of special needs trusts. First is a self-funded special needs trust, and I don't have that on here. Our website does have our outlines on special needs trusts if you'd like to download that. But a self-funded special needs trust where the disabled individual is putting his or her own money into the trust. And with that trust, there is a payback to the Department of Public Welfare upon the death of the disabled person for medical assistance provided during that person's lifetime. Typically, though, DPW only looks for a payback for the time period during the term of the trust. But if it's the person's own money, it has to go into a self-funded trust. Sometimes you need more than one trust, and I'll get to that in just a minute. The second type is a third-party funded trust, and that's the most typical kind in estate planning situations. Mom and dad have 2 disabled children, or I'm sorry, 2 children, one is disabled, one is not. They do a will, everything to the spouse, and then the rest equally divided to the 2 children with the disabled child's going into a third-party funded special needs trust. Now, in a third-party funded special needs trust, in Pennsylvania at least, there is no payback to the Department of Public Welfare. So that money goes to Jimmy, the disabled child, and then when Jimmy passes away, anything's left can pass however the trust states, whether it's to his children, whether it's to other siblings, whatever. There's no payback in Pennsylvania. Other states do have a payback. Pennsylvania does not. In the typical estate planning situation, you're going to have a third-party funded special needs trust, and it might take retirement benefits, it may take life insurance benefits, it may take part of the estate. But whatever it is, it needs to clearly designate that it goes to that third-party funded special needs trust. Now, there are times when you have to use both. Let's say it's an adult disabled child who lost his job, isn't likely to be able to hold a job, has $15,000 in savings, and you can only have $2,000 in savings and qualify for for medical assistance. So to get medical assistance or supplemental security income, you can't have more than $2,000 in the bank. So you want to take $13,000 of his $15,000 and put it in a special needs trust, a self-funded special needs trust. And then the family will have a third-party funded special needs trust to accept the money from the estate. Okay, so the disabled person's own money, if he has some, or it could be a personal injury case, it could be an inheritance of somebody who didn't know to put it in a special needs trust. Wherever the money is coming from that it's his, you put in a self-funded trust. You have to have the payback provision in there or it won't fly because it's his money. But where the family wants to leave money to him from the estate, from insurance, from retirement benefits, from wherever, then it's a third-party funded with no payback. So in the situation I've given you, where there's an adult child with some money, you're really going to need two trusts because you can't commingle the money. You need a self-funded trust for his own money, a third-party funded trust for the inheritance that he's about to get from the family or from the retirement plans or wherever. If you commingle the money, the department is going to say, we can't tell whose money got spent when. We want it all. Or at least you run that risk. So you really need, in a case where the disabled person has money of his or her own, you don't use one trust. You have to have two trusts, and you have to say in the trust it's either self-funded or third-party funded. That's really an important issue. And oftentimes the family will have the IEPs and evaluations that the school district has completed. So I think all of that is useful in deciding, okay, what are we going to do with this child's share? How are we going to distribute the money for this child with a disability? And the typical tool that you use is a special needs trust. Now, there are three basic kinds of special needs trusts. First is a self-funded special needs trust, and I don't have that on here. Our website does have our outlines on special needs trusts if you'd like to download that. But a self-funded special needs trust where the disabled individual is putting his or her own money into the trust. And with that trust, there is a payback to the Department of Public Welfare upon the death of the disabled person for medical assistance provided during that person's lifetime. Typically, though, DPW only looks for a payback for the time period during the term of the trust. But if it's the person's own money, it has to go into a self-funded trust. Sometimes you need more than one trust, and I'll get to that in just a minute.